Welcome to the deep dive.
The place where we really try to cut through the noise.
Exactly. We take these huge foundational concepts and we try to give you that comprehensive understanding, the kind you need to be genuinely well-informed. We're here to give you that shortcut to insight.
Mixing complex theory with hopefully some practical and memorable detail.
And today, we are undertaking a deep dive into an idea so fundamental. I mean, it forms the ethical and legal backbone of nearly every civilization.
But it's one of those things that's often overlooked, right? People see it as just a formality.
They really do. We're talking about natural justice, and specifically one single ancient command that really dictates fairness across all domains. And this deep dive is built entirely on some expert research.
Comprehensive work, really, focusing on the universal applications of this principle.
Yeah.
It's attributed to Mr. Zahir Ahmad Mir.
The core of our whole analysis today is the universal mandate of Audi, Alteram, Partem.
And that might sound like a dusty old phrase from a Latin class.
Right.
But it's not. It's the ultimate stress test for any legitimate decision-making process.
So our mission today is, I'd say, pretty ambitious.
I'd agree. We're not just going to translate the phrase, hear the other side. We really need to understand the profound philosophical and practical consequences of failing to hear the other side.
Because this principle, it's the very essence of what we call procedural legitimacy.
Right. It underpins everything. Global arbitration treaties, internal guidelines for a nonprofit organization, you name it.
So we're going to trace this idea from its philosophical origins. In natural law, we'll explore its heightened ethical formulation in religious thought.
And bring it right into the modern day. We'll see how it's been codified into constitutional law, giving citizens real, actual power.
We want you, the listener, to walk away understanding not just what this rule is, but, and this is the key, why violating it just completely invalidates the entire pursuit of justice. Okay, let's unpack this.
So the foundational concept here is natural justice.
The big umbrella.
It's a philosophical umbrella for this entire discussion, yeah. It really embodies those minimum standards of procedural fairness, the kind of things societies have instinctively demanded for centuries.
Long before written constitutions or, complex legal codes even existed.
Way before.
When we talk about natural justice, it sounds like we're discussing these eternal truths, rules that are somehow inherent to how we interact as humans. How does that contrast with what we'd call positive law?
That's a really crucial distinction.
The statutes and codes that parliaments actually write down.
Right. So positive law is specific. It's written, it varies by jurisdiction. It's the law that tells you what the speed limit is or what the penalty for theft is.
Okay.
Natural justice, on the other hand, is the bedrock. It's the set of moral and procedural axioms that are presumed to exist universally.
So they act as a kind of check on that positive law.
A check on it, exactly. If a government passes a law that violates natural justice, let's say it allows a judge to profit from the verdicts they issue.
That's a clear conflict of interest.
A massive one. And it would be seen as illegitimate by pretty much any higher court, no matter what the statute's wording actually says.
So it provides the fundamental criteria for legitimate governance. If the government passes a law, they have to enforce it justly. And justly means, it means adhering to natural justice.
Precisely. And the legal tradition often breaks natural justice down into two, sometimes three, essential pillars. The first one, which we'll only touch on briefly, is nemo judex in causa sua.
The rule against bias, right?
Yep.
No one should be a judge in their own cause.
Exactly. This makes sure the decision maker is impartial, that they're operating from a clean slate. So that principle addresses the quality of the decision maker.
Okay, the person making the call.
But the second pillar, and this is the subject of our deep dive today, it addresses the quality of the process itself.
And that is the global mandate we mentioned.
That is Audi, Alteram, Partem.
So what does this Latin phrase literally command us to do, and why is that command so weighty?
Literally, it means hear the other side. The weight comes from its mandatory nature. This is not, and I have to stress this is not a suggestion.
It's not a courtesy.
No, not a discretionary courtesy.
Yeah.
Across countless legal and administrative systems, I mean, from ancient Roman courts all the way to the modern United Nations, it's recognized as an absolute procedural prerequisite.
Wow.
It commands that before any judgment is rendered, before any penalty is imposed, or before any binding decision is made that affects a person's rights or their livelihood or reputation.
Anything that matters.
Anything that matters.
Okay.
That party must be given a genuine opportunity to be heard.
I can see the immediate link back to our original point about natural justice. If a system claims to be fair, this is like the bare minimum procedural step it has to take.
It is.
But I want to challenge this for a second. In an age that is just obsessed with efficiency, doesn't mandating the hearing of the other side in every single instance just slow everything down?
That's a critical challenge, and it's one that comes up all the time.
I mean, if the evidence against someone is overwhelming, let's say they were caught on camera, why go through the motions? Isn't that just prioritizing form over function?
Well, while efficiency is vital, fairness is paramount. The whole system collapses without legitimacy. And the principle of Audi, Alteram, Partem demands more than just, 5 minutes of airtime for the other side.
It's more than a checkbox.
Much more. It encompasses several practical, mandatory requirements that ensure the opportunity to be heard is actually genuine.
Okay, let's break those down. What are the procedural requirements that are sort of implicit in hear the other side?
Okay, so first and foremost is adequate notice.
Notice.
The affected party has to be informed of the case against them, the specific allegations, and the time and place of the hearing. And this notice has to be timely enough to let them prepare their defense.
Right, so if you tell someone they're being investigated 5 minutes before the hearing starts.
Then you've technically heard them, but you have violated the mandate. The opportunity wasn't real, it was illusory.
So the notice has to have substance, not just timing. It has to detail the exact claims so the person knows what they're actually defending against.
Absolutely. The second crucial component is disclosure and evidence presentation.
Okay.
The affected party has to be allowed to inspect the evidence that's being used against them. Then they have to be permitted to present their own evidence, their own arguments, their own witnesses.
So that means providing documents, calling experts.
Or even just offering a personal explanation. It's their chance to build their case.
And what about the evidence presented by the other side? Do they just have to accept it at face value?
No, not at all. And that leads to the third major requirement, the right to challenge opposing evidence.
Okay.
In a formal legal setting, we call this the right to cross-examination.
Right.
In an administrative setting, it might mean the right to review documents, submit counter-arguments, and challenge the veracity or the relevance of the claims the accuser made. Without that ability to challenge, the hearing is just a one-way street.
A presentation by the prosecution, followed by
A silent execution.
Yeah. So this is moving way beyond just a polite conversation. This is the rigorous structure of due process.
It is. It ensures the decision-maker gets a comprehensive view of the entire factual matrix, not just the easy one-sided narrative.
It creates a check and a balance.
Exactly. Think of it in the context of professional certification. A lot of our listeners deal with that.
Sure.
If a licensing board decides to revoke your professional license based on a complaint, and they deny you the right to see that written complaint or to question the complainant's testimony,
They've breached the principle.
they have breached Audi Alteram Partem. And that decision, even if it turns out to be factually correct, is fundamentally illegitimate because the procedure was unfair.
That makes the principle incredibly relevant to everyday life. You know, from internal company disputes and performance reviews to university disciplinary boards.
Everywhere.
So if you feel a decision that affected you was handled unfairly, the question you should immediately ask is, was I given adequate notice? Was I shown the evidence against me? And was I allowed to present my side and challenge the claims?
And if the answer is no,
Then a core tenet of natural justice has been denied to you.
and that denial has power. Just understanding the rigor of this mandate empowers you to hold institutions accountable to this universal standard of fairness.
Yeah.
When we talk about codification later, we'll see how this translates into legally enforceable rights. But even purely on an ethical level, it forces the decision maker to justify their procedure, not just their outcome.
It moves the discussion from, did I get the result I wanted, to the much deeper, much more important question, was the process that delivered this result legitimate?
And that shift in focus is what gives the mandate its universal power. It guarantees that the process itself is treated with dignity, with rigor.
Legitimacy through procedure.
Exactly. And this is why philosophically the concept just can't be compromised, which leads us directly to the profound justification that's identified in the source material.
Here's where the mandate moves from a simple procedural rule to a declaration of fundamental ethical necessity. The research attributed to Mr. Zahir Ahmad Mir provides a definitive, really potent statement that serves as the entire philosophical justification, the ratio for this mandate.
And that justification is the statement, ratio. Decision without hearing is injustice per se.
Wow.
And we really have to analyze why that formulation is so critical to law and governance globally.
Okay, walk us through the power of that phrasing, especially the Latin part. Injustice per se. It signifies that the injustice is inherent to the act itself, right? The act of deciding without a hearing, regardless of the ultimate outcome.
Exactly. Per se means by itself or intrinsically. We're dealing here with a fundamental distinction in jurisprudence: procedural versus substantive justice.
Yes.
Substantive justice asks, was the decision factually correct?
Did the person do the thing they're accused of?
Right. But procedural justice asks, was the method used to reach the decision fair?
And the ratio explicitly states that if the procedure is flawed, if the hearing is denied, then the resulting decision is intrinsically unjust, no matter if it was factually correct or not.
Precisely. Let's use a clear, high-stakes example.
Yeah.
Imagine a powerful corporate board fires an executive for gross misconduct,
Okay.
and the board has ironclad internal documentation proving the executive's culpability. Substantively, they are 100% correct.
The facts are on their side.
But they fire the executive instantly. They refuse to let them review the evidence or provide any mitigating factors. They completely deny Audi Alteram Partem. The executive sues.
What happens?
A court reviewing that decision might look at all the evidence and agree the executive deserved to be fired, but they will still quash or invalidate the firing.
Why? Because the process was unfair, even if the result was right.
Yes. The court cannot ratify injustice per se. By denying the hearing, the board acted arbitrarily. The decision is tainted by that procedural fault. The court will often hold that the decision is voidable or maybe even void from the outset.
Meaning they have to start the whole process over again, but correctly this time.
Correctly this time. It emphasizes that procedural fairness is not just some secondary requirement. It is the primary requirement for legitimacy.
That distinction you made, voidable versus void, that's important. Does breaching Audi Alteram Partem usually make a decision completely null and void?
Generally, in administrative law, a breach of natural justice renders the decision void ab initio.
Void from the beginning.
Void from the beginning. It's treated as if the decision was never even made. This is the heavy hammer of the courts.
Oh.
Now, if the fault was just a minor technical irregularity, the decision might be deemed voidable, so it stands unless it's successfully challenged. But denying the right to be heard is typically seen as a fatal jurisdictional error.
Why jurisdictional?
Because the decision-maker never possessed the moral or legal authority to decide in the first place, having failed that minimum standard of fairness.
So this philosophical position, it serves as a powerful bulwark against the arbitrary exercise of power. Why is it so necessary to protect against arbitrariness, even in cases where we think the facts are clear?
Because facts are rarely as clear as they seem when you only view them through a single lens. As we discussed, a decision-maker operating without that dual input is vulnerable to confirmation bias.
Right.
They might genuinely believe the first party's narrative, and so they see hearing the other side as, a waste of time. But the function of Audi Alteram Partem is to force the confrontation of doubt.
It protects the decision-maker from their own cognitive shortcuts.
Precisely. By compelling the hearing, you bring in counter-evidence, context, or mitigating circumstances that might fundamentally alter the meaning of the established facts.
That's a great point.
For instance, the facts may show an employee misused company funds. That's substantive guilt. But the hearing reveals they did so under coercion, or because of a life-threatening medical crisis that was never addressed.
It's a critical context.
It's critical context. The decision to fire them might stand, but the penalty or the subsequent reference they're given might be entirely different. Without the hearing, that crucial context is just lost.
It transforms the search for truth from an investigation into a single story, into a rigorous triangulation of multiple perspectives.
And that rigor is essential to maintaining public faith in the system. The public and the affected parties have to believe that the process was fair, even if the outcome wasn't what they wanted.
Right.
If people perceive that decisions are reached through secret evidence or without letting the accused speak, the system loses its moral authority, and eventually its capacity to govern. The ratio is a constitutional safeguard, ensuring power is exercised legitimately, not just effectively.
But are there ever situations where this fundamental principle has to be, by necessity, compromised? Are there genuine high-stakes exceptions to the mandate?
Yes, and this is where the complexity of legal application really comes in. While the mandate is universal, the law does recognize specific, very limited exceptions.
Like what?
Primarily based on necessity, urgency, or national security.
Let's delve into those. If the principle is so fundamental, how can necessity override it?
Okay, take urgency. If a contaminated food product is discovered and public health is immediately threatened, a government authority might issue an immediate order to shut down the manufacturing plant.
Before giving the owner a full hearing.
Before. Why? Because the delay required for a formal hearing would cause irreversible harm to the public. However, and this is key, even in cases of urgency, the principle isn't permanently abandoned. It is merely postponed.
Okay.
The affected party has to be granted a full retrospective hearing immediately after the emergency action has been taken. We often call it a post-decisional hearing.
So you act first to prevent imminent catastrophe, but then you must retroactively justify that action in a fair hearing. The principle is bent, but it's not broken.
Exactly. The action is legitimate only if that delayed hearing is promised and delivered promptly. Another challenging exception involves national security. A state may detain a suspected terrorist based on intelligence that, for obvious reasons, can't be fully disclosed in a court of law.
Because revealing the intelligence sources and methods would compromise security.
Exactly.
In that situation, Audi Alteram Partem seems impossible to fulfill. The affected party can't challenge evidence they can't even see.
This creates one of the deepest conflicts between state security and individual liberty. Courts internationally have really struggled with this. While the accused may not get full disclosure, courts often mandate that the government must still provide some substance of the allegation.
A summary or a gist of it.
A gist, that's the word, something that allows the accused to meaningfully instruct their counsel, even if the specific, highly sensitive details are withheld. If even that gist is denied, the procedural fairness is usually deemed breached.
And the detention becomes highly questionable.
Highly questionable under international human rights law, yes.
It sounds like the legal system goes to extraordinary lengths to satisfy the spirit of Audi Alteram Partem, even when it can't fully meet the letter of the law.
It does.
The default setting is always procedural fairness must prevail unless there is an overwhelming, time-sensitive reason to defer it.
That's the key takeaway from the ratio. Since the denial of a hearing is injustice per se, the state bears a massive burden of proof to justify that denial. If they can't meet that burden, the decision is arbitrary, it's illegitimate, and it cannot stand. This philosophical underpinning ensures that the mandate serves as a true, constant check on power.
We've established the global mandate in Latin and the universal philosophical justification for why we have to adhere to it. Now, let's move from this generalized concept to how this principle, rooted in fundamental human ethics, has been explicitly codified and even amplified within a specific, profound religious context. This is a focus point highlighted in the research by Mr. Zahir Ahmad Mir.
This is where the concept of fairness transforms from a passive procedural right into an active positive duty that's required of the adjudicator. While Audi Alteram Partem is the standard command, the Islamic formulation provided in the research adds an ethical layer that sets an even higher benchmark for justice.
Introduce that formulation for us again.
It's a command addressed directly to the adjudicator or the judge. It says, "Hear both sides, even if one is silent."
That small clause, even if one is silent, that is absolutely transformative.
It's huge.
The Latin is a command to hear, but it kind of implies the parties are actively speaking. The Islamic text adds this compelling, much deeper duty that's focused on the decider's responsibility.
Exactly. The Latin formulation establishes the right of the accused party to speak. If that party is fully capable and willingly chooses to waive that right, the process can often proceed legitimately.
But not here.
But the formulation, "hear both sides, even if one is silent," fundamentally shifts the burden.
How does this active duty change the process compared to the passive right?
It forces the adjudicator to become an active agent of inquiry. The judge cannot simply say, "Well, the accused didn't present a defense, so I rule against them." The judge must first seek to understand why that silence exists, and if necessary, actively investigate or represent the interests of that silent party to ensure that the material facts pertinent to their side are brought forward.
Let's explore the possible reasons for that silence. It's often not guilt, as we noted before. The research really compels us to consider the underlying dynamics here.
And the silence usually indicates a critical power imbalance or some kind of vulnerability.
Like what?
Well, consider fear and intimidation. A vulnerable party facing a powerful state entity, a wealthy corporation, or an influential person might be terrified to speak openly. They might fear retribution or further loss.
So in that scenario,
In that scenario, the adjudicator has to use their authority to create a safe space. maybe through procedural protections or separate testimony, ensuring the evidence isn't suppressed by fear.
And what about ignorance of process? Most legal procedures are, frankly, opaque and terrifying to the average person.
That is a massive factor. An unrepresented person, ignorant of complex rules about evidence, deadlines, or even what constitutes a relevant fact, might stay silent simply because they don't know how to speak or what to say.
So what's the judge's duty then?
The judge, adhering to this silent-side mandate, has to take steps, maybe by appointing an amicus curiae, a friend of the court, or by proactively asking probing, clarifying questions. They have to distill the relevant facts that the silent party failed to articulate.
It's a duty to prevent justice from becoming just a test of legal literacy.
Exactly.
We also have scenarios of physical or language barriers. If someone is physically unable to attend or needs an interpreter that the system doesn't provide, their silence isn't a waiver of their right.
Absolutely not. The mandate requires the decider to ensure that all necessary accommodations are provided so the communication pathway is genuinely open. If a process goes ahead without adequate translation, the decision is clearly made without hearing the other side.
Which renders it intrinsically unjust.
Intrinsically unjust.
This formulation, therefore, imposes a responsibility on the system to ensure substantive access to justice, not just formal access.
That's the core difference. It moves beyond just checking off a procedural list. It demands an ethical commitment to the truth. When the decider encounters silence, they are ethically compelled to ask, is this silence a surrender, or is it a symptom of a failure in the system to adequately protect this party?
This proactive stance, it resonates globally, even outside of Islamic jurisprudence. You can see analogs in the historical development of Western common law, particularly with the rights of the accused and the evolution of legal aid.
Oh, for.
While it's not always phrased as even if silent, the spirit of ensuring the unrepresented are considered is foundational. The move towards public defenders and mandated legal representation in high-stakes cases reflects the societal recognition that procedural justice fails when vulnerability dictates the outcome.
Precisely. And if we look back to ancient Roman law, which gave us the Latin phrase, the principle was often enforced most rigorously for the wealthy and the politically connected.
Of course.
It took centuries of ethical amplification, often driven by religious and philosophical thought, to extend that protection universally, particularly to those who lack the means or the knowledge to assert their rights. The Islamic formulation is a stunning example of codifying this enhanced, mandatory protective duty centuries ago.
So whether we use the global legal phrasing, Audi, Alteram, Partem, or the ethically amplified phrasing, hear both sides even if one is silent, the universal ethical core is undeniable. Truth requires dual input, and justice demands the active consideration of the vulnerable.
And this convergence across different legal and ethical traditions, from ancient Latin maxims to profound religious instruction, is a powerful testament to the fundamental human necessity of a fair process. It's not a cultural quirk. It is a structural requirement for any society that aims for legitimacy.
So the ultimate purpose, then, is to prevent the decider from falling prey to incomplete information that's fueled by power imbalances or fear or complexity.
Exactly. It ensures that the responsibility for uncovering the truth rests with the adjudicator, not just with the eloquence of the lawyers.
It forces critical thinking, and it mandates skepticism toward the easier, one-sided narrative.
Indeed.
We've traveled from the philosophical foundation to the ethical high watermark. Now we have to ground this universal principle in the practical machinery of modern law. This is where that abstract maxim transforms into a tangible, enforceable right.
Specifically, addressing how arbitrary power is checked by a constitutional mandate.
Right.
And the research by Mr. Zahir Ahmad Mir highlights a compelling modern example of this codification within a national context. The constitutional law of Pakistan, specifically Article 10A.
What's the significance of enshrining a principle of natural justice, which usually exists as a common law concept or an inherent power of the courts, into a formal, explicit article of the Constitution?
The significance is profound. It's because it grants the principle immunity and supremacy.
Okay.
When Audi Alteram Partem exists only as common law, it can sometimes be overridden or limited by specific parliamentary statutes or administrative regulations. Courts are reluctant, but it can happen.
But when it becomes Article 10A...
When it becomes a fundamental part of the constitutional structure, it becomes the supreme law of the land. It's an inalienable right guaranteed to every single citizen.
So that means no administrative body, No tax collector, no ministry, and potentially no piece of legislation can violate the right to a fair hearing without being challenged on constitutional grounds.
Exactly. Article 10A guarantees the right to a fair trial and due process. By explicitly giving the right to be heard constitutional status, it provides the citizen with the strongest possible legal remedy if this right is infringed.
So it moves the argument from that was procedurally unfair under some obscure regulation to
The state has violated my fundamental constitutional right. It's a much more powerful claim.
let's discuss the practical impact of this. For the everyday citizen and for the government apparatus, where does Article 10A most effectively check arbitrary power?
It acts most potently in the realm of administrative law. That is, decisions made by government agencies outside of traditional criminal courtrooms.
So we're thinking about decisions regarding permits, licenses.
Dismissals of civil servants, tax assessments, property seizures. These are high-stakes decisions that are often made rapidly by a bureaucracy, not by a neutral judge.
Okay, hypothetically, let's take the case of a civil servant dismissal. A government employee is accused of corruption, and the departmental head decides on an immediate summary dismissal based on some internal report.
In a pre-Article 10A world, that employee might have had very limited recourse. But with Article 10A, the employee can immediately petition the High Court.
And they don't have to prove they weren't corrupt.
No, that's
Yeah.
the key. They only have to prove that they were dismissed without being given notice of the charges, the evidence against them, or a genuine opportunity to present their defense.
And the court, applying the ratio we discussed, decision without hearing is injustice per se, would strike down the dismissal purely on procedural grounds.
That is the power of codification. The court would declare the dismissal void, not because they found the employee innocent, but because the government acted unconstitutionally by failing to follow the mandate of fairness.
And the government would have to reinstate the employee and start the disciplinary process all over again.
Over again, ensuring they adhere fully to Audi, Alteram, Partem. This serves as a clear, chilling signal to all administrative bodies that they cannot substitute expediency for fairness.
This mechanism, judicial review, based on procedural constitutional flaws, is really the heart of the protection.
It is. It makes the procedure legally binding, not just ethically desirable.
Yeah.
And it creates a vital distinction in legal challenge known as the collateral attack. When a citizen challenges a decision based on Article 10A, they are mounting a collateral attack on the process itself.
So they're not asking the court to re-examine the facts of whether they committed corruption or tax fraud.
No, they're asking the court to evaluate the legitimacy of the authority that made the decision in the first place.
And since legitimate authority requires adherence to natural justice,
A breach of Article 10A means the authority acted without legal foundation.
the codification also forces the bureaucracy to be disciplined and transparent, rather than opaque and arbitrary. They know their records are going to be scrutinized.
And not for the accuracy of their factual findings, but for the demonstrable steps they took to ensure the affected party was heard.
Right.
Imagine a large government project that requires the compulsory acquisition of land. The law requires a fair hearing to determine compensation. If the Land Acquisition Authority decides on compensation without allowing the landowners to present their own valuation reports or challenge the state's assessment,
That entire proceeding is unconstitutional under Article 10A.
regardless of how fair the compensation seemed, the landowners have an immediate, powerful constitutional remedy.
This transformation from ethical norm to constitutional right is so crucial for developing robust governance. It shows how these philosophical ideals translate into tangible real-world constraints on power.
It connects the ancient Roman maxim, amplified by religious ethics, directly to the modern citizen's wallet, their livelihood, and their liberty. It is the democratization of due process. When you understand the strength of an article like 10A, you understand that in that jurisdiction, the right to be heard is absolutely foundational to legal existence. The state cannot act secretly or unilaterally against the interests of its citizens.
It domesticates the global mandate. We see that concept, which is universally demanded, becoming a living, breathing part of national law.
And it ensures that the promise of fairness is backed by the full power of the judiciary. This legal enforcement closes the loop on our entire discussion, proving that this mandate is just indispensable.
And its indispensability rests entirely on that philosophical justification.
Without fairness of procedure, you have no foundation for justice at all.
This deep dive has truly unpacked the universal mandate of Audi Alteram Partem. It's a deceptively simple phrase carrying the weight of global ethical standards and legal tradition.
We track the concept from that generalized philosophical umbrella of natural justice, defining it as the minimum procedural standard for legitimacy, right alongside the rule against bias.
We analyzed its powerful philosophical root, the ratio, which states definitively that decision without hearing is injustice per se.
Which forces legal systems globally to prioritize procedural fairness over mere expediency or, their desired factual outcomes.
We then saw that concept amplified ethically in the Islamic formulation. Hear both sides even if one is silent.
Which transforms the right of the individual into an active, positive duty of the adjudicator to seek truth, especially when dealing with the vulnerable, the ignorant, or the intimidated.
And finally, we connected that universal ethical mandate to modern tangible protections. We used the example of its codification in national law, like Pakistan's Article 10A.
Which gives citizens the constitutional power to enforce this right against arbitrary administrative and governmental action, guaranteeing judicial review on procedural grounds.
This entire exploration was built on the comprehensive and, frankly, illuminating research provided by Mr. Zahir Ahmad Mir.
It's a stunning illustration of how core ethical wisdom transcends time and culture.
And becomes the enforceable law that protects millions. So what does this all mean for you, the listener, beyond the courts and constitutional articles?
It means that while we often reserve the rigor of Audi, Alteram, Partem for high courts and disciplinary hearings, the principle holds the highest ethical weight in every single domain of human decision-making. If the law dictates that a decision without a hearing is injustice per se, then we have to apply that mandate ourselves.
That's a powerful thought.
Think about the judgments you form daily. In team meetings, when you're assessing a competitor, when you're discussing a controversial social issue, or even when mediating a disagreement between your own children.
In every instance where you are the decider or the informed observer.
There's a silent side. And that side might be silent because it's unpopular or inconvenient or lacks a sophisticated voice, or it's simply too complex to fit into a headline.
The provocative thought we want to leave you with is this. The highest form of justice requires more than just passive tolerance of alternative views. It requires proactive, active inquiry. Are you, in your own sphere of influence, acting as an adjudicator who only respects the right to be heard?
Or are you acting as a decider who embraces the duty to seek out the truth, even if the other side is silent? Apply the mandate in your life. Actively seek the perspective that is hardest to access or most likely to be ignored.
We hope you feel a little more well-informed and perhaps a little more ethically equipped. Thank you for joining us for this deep dive.
We'll see you next time.